Be ready? Start. Nonetheless, as noticed above, and which is evident from the records, the Tehsildar himself processed the file and recommended that the leases were valid and did not suffer from any infirmity. Stop. In essence and in pith and substance, the Tehsildar applied his mind to the said allotments and accordingly made a recommendation that the petitioners were eligible to receive the said allotment of lease from the Gaon Sabha. Stop. In the opinion of the court, once the Tehsildar had applied his mind being the competent authority for approval, then in that view of the matter, the Tehsildar will be presumed to have approved the said allotment in favor of the petitioners, and which has been noticed by this court while granting an interim order on 22nd January 2008. Stop. This act of the Tehsildar, even though subsequent in point of time, cannot be faulted with. Stop. The factum of the report and recommendation of the Tehsildar has been noticed in the impugned orders. Stop. This fact has been stated in para 7 of the petition and has been accepted as a matter of record in para 5 of the counter affidavit of the private respondent. Stop. The same has also not been questioned or disputed in the counter affidavit. Stop. Here. The Tehsildar, therefore, having recommended favorably, will be presumed to have applied his mind to the same. Stop. To approve means to be in favor of or to judge favorably. Stop. It is to favorably sanction and confirm an act. Stop. This expression is an act of approval ratifying an authorized act. Stop. It is an assent which is an approbation through a formal attestation. Stop. The Tehsildar's recommendation was favorable to the petitioners and therefore it was a conduct by a competent official approving the allotment. Stop. The respondents have not been able to bring on record any material to the contrary, nor has the state filed any affidavit of the Tehsildar controverting the said fact. Stop. Here. In the circumstances, it cannot be said that the approval was bereft of any orders of the Tehsildar, who was the authority competent to grant the approval. Stop. Putting of signatures by the subdivisional magistrate might therefore be superfluous, but the exercise of the discretion by the Tehsildar in supporting the recommendations cannot be said to be an act either without authority or without jurisdiction. Stop. In the opinion of the court, the recommendation made by the Tehsildar will amount to his approval, and in the aforesaid circumstances, the findings recorded by the authorities below on that count cannot be sustained. Stop. The impugned orders dated 29th August 2007 and 31st December 2007 are hereby quashed for the aforesaid reasons. Stop. Here. So far as the issue of eligibility of the petitioners and the issue of cancellation on other grounds of irregularity is concerned, it is open to the collector to take appropriate action in case he finds that the allotments were otherwise made in favor of ineligible persons, provided that the limitation as prescribed under the provisions of section 198 permit him to proceed to do so. Stop. Para. The writ petition is allowed subject to the aforesaid observations. Stop.